Hey everybody, this will hopefully be the much anticipated short video. Last week, you don't have any assignments this week, get yourself ready for finals. The final will open up a little bit later in the week. It's unfortunate because this is really an important portion of the course. And I realize that Dr. Friedella wrote this book with the idea of taking you logically, step by step, doing some initial work and then talking about the arrest, through arraignment and then conviction, or the trial process, conviction, sentencing, and now the appeal. But out of all of the sections, something that you're going to run into time and again is going to be the stuff from the appeal. What I mean by that is when you go to 340 and 350 next semester or next year, you're going to be pounded with cases. And I'll be honest with you, I would venture to say many of you, especially those of you that don't spend any time in this chapter because you're too busy elsewhere, you're going to be lost and you're not going to understand what standard of review means. You're not going to understand how a case gets to the appellate court. And the only reason I say that is because I teach both of those courses and I see that all the time. The first big piece of advice I have for you, it's really difficult because they're long. The thought process can be complex, although it's very logical. But just take the time to actually read a case when one's assigned. Don't jump on the internet and pull up the first case brief you find. Time and time again, I find that they're not accurate. They're not very well done. They give main points, and oftentimes those main points are incorrect. So, this week, let's get some ground rules figured out. And I think the first one is the idea of appellate review versus habeas corpus. This is also known as post-conviction relief. So when a person is convicted, they have the ability for one appeal, and that's a right. And once they get to that, or once they get past that, all subsequent appeals are discretionary by the court. So take California as an example. California, a person's convicted, well, they have the right to appeal to one of the several district appellate courts in the state. And once the appellate court rules, and what is going on at the appellate level is there's a discussion as to whether or not there were procedural errors in the trial. And that concept is, word to write down, it's fundamental fairness. If there was fairness and there are no procedural errors that amount to reversible error, then the appellate court will uphold the standard or uphold the decision of the trial court. Now, you're going to see tons of these cases, and quite a few of them you're going to see are going to be where there's reversals. And I think that's just kind of the nature of the commentators who write for our level, for that 300 and 400 level, junior and senior class. But there's a lot of cases that affirm prior law, and hopefully the prior law will be looked at too. You'll see that for sure when you talk about things like Terry, as you talk about other important landmark cases. So keep that in mind. The next issue is what happens with habeas. What's habeas about? Well, habeas is best put as a challenge to unlawful confinement. So, person gets arrested and prosecuted for a crime. They get convicted. They go to jail. They appeal. They lose their appeal. But there is they believe their confinement is unlawful because the court didn't follow the law, there is additional evidence, something of that nature. There's evidence that a confession that the arrest or conviction was based on was unlawfully obtained. Things of that nature. Well, then you'll see this challenged unlawful confinement. And the way to tell is if you have a criminal case and the case title are two names. So if it's Smith versus Jones and it's a habeas corpus action on a robbery conviction, well, you know that it's a criminal case and they're going to be talking about criminal law issues, procedural or substantive criminal law issues. So make sure you have that idea because that's a really important distinction. And then the other thing I would like you to have a really good handle on is understand, the process, conviction, notice of appeal, filing of briefs with the proper court, obtaining a record of the trial if one exists, and having that moved to the proper appellate court. Now, if a person gets convicted of a misdemeanor, they don't immediately appeal to in California to the district court. They would appeal initially to an appellate division of the Superior Court. So in the case of Los Angeles County, if that happens, the case doesn't leave the LA Criminal Courts building. It stays there. And then only after there is a judgment by the appellate division of a significant point of law, and the defendant is still in jeopardy, meaning that the appellate division agrees with the trial court, only then can a misdemeanor case then go on to the appellate court. That's why you don't see very many misdemeanor cases at the appellate level. Many discussions on them. You do occasionally, DUI comes up a lot. There's been some significant DUI cases, like the idea of forcing blood. There was a case in California, Schmerber versus California, that for years was I don't want to say gold standard, but okay, it's the gold standard of the forced blood issue. And eventually that was challenged, and the case has since been overturned by the U.S. Supreme Court, and now anytime the police need to force blood, meaning a person says, no, I'm not going to give you blood or a breath test voluntarily after their arrest, well, their driver's license is one issue. Once they say no, even with pretty good counsel, it's not likely that they're going to be able to maintain their driving privilege. But the second issue is the evidence of their intoxication, their chemical evidence. So the police now need to obtain a warrant. And there's still some litigation, and I'm not, as an attorney, I still think there's some clarification the courts need to do, especially with the way that the police handle it. I mean, Arizona is a good example of kind of a boilerplate warrant where it's a checkbox deal. And I don't know if that meets the Fourth Amendment's require particularity. But that's an issue for your 350 class. So make sure you go through this. My sense is I probably haven't been all that great in keeping this short, but super important chapter. Please take the time for it. If you're going to go to law school, take the time, understand it. If you're going to go into police work, take the time and understand it. If you're going to take 340 and 350, take the time, have a pretty good handle on it for those courses. I'm a real stickler on it when I get to those courses. And I know at least one other professor that is also a real stickler on it. Because people don't understand. People don't understand the difference between the trial court and the grand jury or the appellate court. So make sure you take that time and do that. I hope you've enjoyed the course. I hope you have learned some stuff. and that you find the course has been helpful for you, and especially as you get into your other classes. But with that said, thank you very much. Have a good holiday season, and if you haven't taken 302 yet, I might see you in 302. Next semester, there's a chance I'll be teaching 350, but we'll see how that breaks out. There's a lot going on in the department right now, trying to get everything squared away. So that being said, we'll see you guys in class. Good luck on the final.